All right, hello. My name is Kevin Muhlendorf. I'm a partner in the Wiley Rein white collar and government investigations practice. I used to be a federal prosecutor, and before that, I was a SEC enforcement attorney.
My name is Maddie Cohen. I'm a fifth-year associate at Wiley Rein, and I work closely with Kevin on some of our SEC cases.
Yeah, so today we're going to talk about the SEC's Whistleblower Program. Just recently, the SEC issued a report to Congress on its fiscal year 2018 Whistleblower Program successes, and we thought it made sense to talk about that and go through some of the cases they discussed and how the program has been progressing over the years. As a little background to the program, it's a relatively new program in the history of the SEC. Prior to Dodd-Frank, the SEC was only able to issue whistleblower awards in insider trading cases, but after the Madoff scandal in 2010 or thereabouts, Congress passed Dodd-Frank, and part of that required the SEC to put together a whistleblower program. And they passed rules in 2011 that spawned the Office of the Whistleblower and the Whistleblower Program as we currently know it. In a nutshell, the current whistleblower program allows successful whistleblowers to be awarded between 10 and 30% of sanctions recovered by the SEC once those sanctions reach $1 million.
Kevin, could you give us a little background on some of the basic requirements of the SEC Whistleblower Program? What does it take to be a whistleblower? What information do you have to provide, et cetera?
Yeah, absolutely. And to start, one of the best resources for this, besides the multitude of law firm alerts and law firm websites, is the SEC's website itself. If you go to www.sec.gov/whistleblower/frequently-asked-questions, the SEC has helpfully put together a whole series of questions that addresses the various requirements and the various rules under the whistleblower program. But basically speaking, in order to be an SEC whistleblower, a successful whistleblower, and obtain an award, you need to voluntarily provide original information about a securities law violation that has occurred, is ongoing, or is about to occur, and one that leads to a successful action, as I said, a successful recovery in monetary sanctions exceeding $1 million. So briefly, what do each of those things mean? Well, voluntarily means that you're not under compulsion, and it's before the regulator or a regulator other than the SEC has come to you or your lawyer asking for information. That includes Congress. So if Congress has asked you for information, you are no longer voluntarily providing it for purposes of the whistleblower program. Original information, what does that mean? Well, derived from your own independent knowledge, not publicly available. So that's what we think of as a sort of traditional whistleblower, as an insider. But it can also be derived from independent analysis of publicly available information that reveals information not generally known. And in either case, the information has to not yet be known by the SEC. A securities law violation that is ongoing or about to occur, and that's pretty self-explanatory. And the portion about sanctions exceeding $1 million, that's when we talk about a successful SEC action, that can mean causing the SEC to open an investigation, reopening a previously closed investigation, pursuing a new line of inquiry in an existing investigation. And importantly, and we're going to talk about this a little bit later in the context of retaliation, a successful whistleblower can report internally first to the company and has 120 days to report to the SEC. Additionally, as I mentioned, you can be an outsider, someone who's not part of the company, in addition to being a former employee, and you can be a foreign citizen, and we'll go through some cases that have addressed that. And finally, one of the most important questions that whistleblowers often ask is, can I do this anonymously? Obviously, it's sort of traumatic to be a whistleblower, and you worry about sort of retaliation. But yes, you can. Through an attorney, you can submit anonymously. And the SEC takes the confidentiality of its whistleblowers pretty seriously, although they do caution, as you'll see in the frequently asked questions, that they will try and protect your anonymity. However, if the case goes to court or if there's a criminal case, it might be that your name has to be surfaced. So, Maddie, why don't you tell us about some of the highlights from the fiscal year 2018 Whistleblower Report?
Sure. As you mentioned, the report covers fiscal year 2018, and it was provided to Congress in November of this year. In the report, the SEC states that it received 5,282 tips in 2018, which is up from 3,001 in 2012, and the number of tips has grown each year in between. In 2018, the SEC awarded $168 million to whistleblowers, including the two highest ever awards to 5 individuals. $83 million went to 3 individuals, and another $54 million went to 2 others. That's out of a total of $326 million to 59 awardees since the inception of the Whistleblower Program. The amounts of these awards compared to those in prior years is pretty significant. It's also important to keep in mind that a small number of whistleblower awards in any given year does not mean a small number of investigations. These cases take years to investigate and resolve, so it's not surprising that the increased volume in whistleblower tips over the past few years is just now starting to result in resolutions eligible for whistleblower awards. And something else interesting the report highlighted were the different types of awards and the different awardees. So, Kevin, could you tell us a little bit more about that?
Yeah, absolutely. So the types of cases that the whistleblowers tend to report has remained relatively consistent. The largest number this year were offering frauds, followed by corporate disclosures, market manipulations, insider trading, unregistered offerings, and then FCPA-type whistleblower cases. The report very helpfully went through a few highlight cases to make points about the types of things the SEC is focused on in this program. So, for example, in September of 2018, an overseas whistleblower was awarded $4 million. As I mentioned earlier, foreign whistleblowers are eligible. The order in that case noted that the SEC's enforcement case, was opened as a direct result of the tip, and the claimant provided extensive assistance to the commission staff throughout the course of the investigation. And you'll hear as I go through these that the amount of assistance provided by the whistleblower tends to be a recurring theme. So then in April of 2018, the SEC highlighted a $2.2 million award to a whistleblower who first reported to another agency. And this was the first time, as noted in the report, that the SEC had issued a whistleblower award to someone who came forward to another agency first and then reported the same information to the SEC. Under one of the whistleblower rules, you have 120 days to report that information to the SEC. In the order describing this award, this $2.2 million award, the SEC referenced the, quote, substantial cooperation. And the chief of the Office of the Whistleblower in the press release noted that the rule was designed to help the uninformed, unrepresented whistleblowers who don't know exactly where to report it first. The order itself noted that the SEC had already opened its investigation based on the initial referral, but credited the whistleblower with the case opening that the referral would have caused if it had gone straight to the SEC. In this instance, it was a former company insider who provided the ongoing helpful assistance. And finally, the report noted a $1 million award to a company outsider. That company outsider provided new information and substantial corroborating documentation of a securities law violation by a registered entity that impacted retail investors. So, as I said a few seconds ago, each of these awards and each of these highlights in the report pointed out the type of assistance that the whistleblower was able to provide. So it seems that the SEC is trying to get across the point that in addition to putting them onto a case, the more information, the more help you can provide, the more likely you are to get an award. One thing of note in the report was the location of the whistleblowers in 2018. So the location of the whistleblowers was also highlighted in the report. They came from all over the world, but Canada, UK, and Australia led the way. Interestingly, China, India, Brazil, Germany, Russia, and Spain all generated between 15 and 40 tips last year. So we mentioned earlier a little bit about retaliation. So Maddie, why don't you tell us about this key retaliation case we talked about, anti-retaliation case out of the Supreme Court this year?
Sure. Well, as I mentioned earlier, the number of whistleblower tips has continually increased over the past few years, and while high dollar awards given to whistleblowers recently have probably helped drive this increase, an important anti-retaliation Supreme Court case decided earlier this year is also at least partially responsible for pushing whistleblowers to report to the SEC. In Digital Realty Trust v. Somers, the Supreme Court resolved a circuit split over Dodd-Frank's definition of a whistleblower for purposes of the statute's anti-retaliation provisions. The court held that to qualify for the protections, an individual must report the suspected misconduct to the SEC. An employee who reports misconduct internally, but not to the commission, is not considered a whistleblower for purposes of these protections. What that means for the SEC's program is that to receive the protection of the statute's anti-retaliation protections, a whistleblower must report to the SEC. Potential whistleblowers are thus likely to report to the commission in greater numbers to ensure that they don't lose these protections.
So, Maddie, one thing that we should probably mention is that digital realty trust didn't alter the definition under Sarbanes-Oxley, which is a separate whistleblower retaliation program. And so under Sarbox, you do have protections for reporting internally. But one of the reasons most people, whistleblowers, want to be Dodd-Frank whistleblowers is because that retaliation protection comes with a potential for a larger award and a less stringent timeline than under Sarbanes-Oxley.
Absolutely. And another important aspect of the Dodd-Frank protections is that they allow the SEC to bring affirmative enforcement actions against companies for retaliation. The SEC highlighted in the 2018 report that it has so far done so on 3 occasions. For example, in the matter of international game technology, a company employee who had received favorable reviews in the past raised concerns to the company's internal hotline and to the SEC regarding the company's public financial statements. And the company did an audit, determined that its financial statements were accurate, but then fired the whistleblower. The company was forced to pay $500,000 in civil penalties as a result of this action. Another good example is in the matter of Paradigm Capital Management, Inc. There, the head trader of Paradigm, an investment advisor company, informed the company that he had reported potential securities law violations to the SEC. The very next day, the company relieved the whistleblower of his trading and supervisory duties, restricted his access to email and to the company's trading network, made him look at hard copy documents instead of accessing any documents online. And eventually, as a result of this marginalizing within the company, the whistleblower resigned. And the SEC required Paradigm to disgorge $1.7 million, pay a civil penalty of $300,000, and retain an independent compliance consultant as the result of both its fraudulent conduct and its retaliation. The SEC has also brought 9 enforcement actions against companies for acting to prevent employees from reporting. So whether that's through their separation agreements or company confidentiality policies, companies will sometimes try to prevent their employees or former employees from using any information they've learned at the company to report to the SEC. And as I mentioned, the SEC can use its affirmative enforcement authority to go after companies for that as well.
Yeah, that provision, Maddie, Rule 21F17A, has come up several times, and it seems like the penalties are getting a little steeper. One thing that's always sort of surprised us in our practice is when you talk to people about this, they don't still seem to be aware of it. So that's one of the things we're counseling people to do is to, if you're a company, to take a look at that separation agreement and a confidentiality agreement and make sure that you're compliant with this rule so that you don't get jammed up on something that not even a retaliation issue, but just the way a legacy form has been created could cause you problems even today. All right, Maddie, why don't you talk about some key takeaways from the report?
Sure. I think one of the biggest takeaways from this past year for companies is the effect of digital realty trust. Now that reporting employees will not receive full whistleblower protection until they report to the SEC, more potential whistleblowers will likely take their allegations to the commission. But companies still have a window of opportunity to act before an employee reports to the government. Once an employee internally reports suspected misconduct, companies should diligently investigate and ensure that the reporting employee knows that the company takes the allegation seriously. By acting quickly and acknowledging the value of the employee's report, companies may be able to internally resolve issues and satisfy the employee before they become a potential whistleblower and further report to the government.
Yeah, and I think if you look at the reports and you look at the sort of eye-popping figures that came out this year, that certainly gets everyone's attention. The drumbeat of these multi-million-dollar awards will, probably lead to an increase in the number of quality leads the commission receives. From a whistleblower point of view, given the thousands of tips the SEC receives every year and the growing number, whistleblowers that want to stand out, they're really going to need to provide some well-packaged information that makes the SEC's job easier in order to get to the top of that list. And as we saw, that often means providing substantial assistance throughout the investigation. In order to make that work, whistleblowers would be well served to find experienced counsel that can help them get the information and package it the way the SEC wants it, so it rises to the top of that heap. And similarly, with the rise of the number of tips and the continued enforcement of 21F17A, companies really need to take a look at their whole compliance program, and it should be a renewed incentive to double down on internal compliance and ethics hotlines. Study after study has shown, and we find this in the companies we work with, that companies that have a program in place to address how their employees are dealing with internal problems, addressing employee concerns, if that's dealt with on the front end and people feel like they're being valued, often that prevents them from becoming whistleblowers. And please review those confidentiality agreements and severance agreements and make sure that they won't be interpreted by the Commission to inhibit communications with the staff. All right. Well, thanks very much, Maddie. This was fun.
Thank you, everyone.